Okay, then. Okay, should we stand for the pledge? The pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Patty, can you use the mic?
All right. Let the records indicate that all members are present.
Still not getting you, Patty.
How's that?
Yeah.
There you go.
Better?
Okay.
All members are present tonight with the exception of Mr. Brevich. Do we have any additions or deletions from the agenda?
I'll make a motion that we accept the agenda as presented.
Support.
Motion and support to accept the agenda as presented. All in favor?
Aye.
Opposed? Motion carried. Okay, we have the minutes from our last meeting.
I'll make a motion that we accept the minutes as presented.
I'll support that.
Motion and support to accept the minutes from our last meeting. All in favor?
Aye.
Opposed? Motion carried. Okay, under unfinished business, we have Florence Hanson and Heritage Cove Farm. Request for a special use permit. We closed the public hearing, so this is strictly board discussion and guidance from our legal counsel and staff.
Good evening, everyone, and for those in the audience. My name is Peter Wendling, an attorney for civil counsel for the county. I know that the Planning Commission will probably have a variety of questions, but I wanted to start off and provide some guidance before you take a look at the draft findings of fact. These draft findings were put together, through our office, but also with the assistance of your staff as well. As I always state, when you have findings of fact, you are free to use them, you're free to amend them, you're free not to use them, you're free to use your own findings. All that I ask is that we make a finding that it is supported by competent, material, and substantial evidence on the record, which means that you utilize the exhibits that you've received throughout these proceedings until the public hearing is closed. That being said, this issue is a little more complex than most, not because I believe it has anything to do with the type of activity which is being proposed for the property. But first and foremost, which probably is a little bit of confusion, is the fact that this property is bifurcated into two separate zoning districts, MAF and PLS district. There are different uses that are allowed in each zoning district, and under Michigan law, when you propose a use in the zoning district, you have to have a primary use proposed in that district. That's regardless of whether a single property is bifurcated by two separate zoning districts. That is the reason why you have primary uses being proposed in the MAF district, and of course the two primary uses being proposed in the PLS district, the cabin colony and the restaurant/cafeteria, or I guess we'll have that discussion as well. I'm going to start off with actually the PLS district because I think that's the more difficult one, because it's very hard and probably conceptually for the Planning Commission to say, well, what's the difference here? Why should we consider this a separate use? This is an overall use. It's a Heritage Cove Farm. It's a therapeutic farm. All these things are interconnected on the same property. Why should we take a look at a separate primary use in the PLS district when in fact it's all part and parcel of what the applicant's overall plan is? Well, as I explained, it's because you do have to have those primary uses first listed in each district and offered up for a special use permit. The second issue then is, well, if it's a cabin colony, is there any provision in the ordinance that states that you have to have a specific reason for a cabin colony? And I suggest to the Planning Commission that no, the reason for it is not part of the land use review under the PLS district or for any zoning district. So let's say someone approached the county and they asked for a special use permit for a cabin colony, which would be for people who are mentally disabled. Forget about the therapy provision in there. Forget about any other use other than that they're being housed there, and that they have a restaurant facility which they're going to utilize to feed themselves when they reside in the cabin colony. Does that make a difference as to whether or not those uses are allowed? Well, if they meet the standards under the ordinance for a special use permit, the fact that they're mentally disabled is completely irrelevant to the use being proposed. The same is true for a cafeteria. Let's substitute in, let's say the VFW buys that property and they want to put in the PLS district a cabin colony for veterans, and they're going to have a restaurant there with the social hall, and the restaurant is not utilized for serving the public. It's only used for the VFW people. They may open it to the public on Fridays. I know it's a VFW post where my mother lives in Manistee. They have Friday fish fries, but other than that, that post in that restaurant is for the members of that post. Does it make it any less of a restaurant because of that? I suggest the Planning Commission, the answer would be no. So I don't want the Planning Commission to get too bogged down on the issue as to why the applicant is requesting what he's requesting. The issue is whether it's allowed in the zoning district, the cabin colony, regardless of the reason. And the issue is the restaurant allowed, regardless of the purpose behind it, or cafeteria in the PLS district? And if so, do they meet the zoning standards? Only if you get to a point in your deliberations where you determine that the standards are not being met for the reasons stated in the zoning ordinance, do we even get to the reasonable accommodation questions involved. And perhaps we won't get there, perhaps we will. Now let's take a look at the MAF district. That's where the analogous, I guess we would say, convalescent home use is being proposed. Now, is there anything in the zoning ordinance that says a convalescent home is required to be in a single structure? I didn't see anything in the zoning ordinance that required that. In fact, many such homes have multiple buildings, wings, therapy wings. They're also used for housing. They may also have cooking facilities, although it's not being proposed in this particular application here. And in convalescent homes, it's not just the elderly or the infirm. In fact, with the passage of the Affordable Care Act, more and more, these homes are being utilized for recovery from surgeries for therapy purposes, physical therapy, therapy as a result of from having a stroke, things of that nature. So it's not just the elderly that are in many of these facilities. There's a variety of people with a variety of ailments and a variety of ages that are now utilizing these facilities. An example I can provide is the medical care facility in Bel Air has a rehabilitation wing. It's people who are suffering from a variety of ailments. Doesn't matter how old they are, they go there and they receive treatment. They receive treatment whether it's for Medicaid, Medicare, or private insurance or private pay. Doesn't make a difference. So when you take a look at that, it's not, again, an issue of whether or not the party is disabled. It's whether or not the use or the people who will be utilizing are disabled with a mental impairment. But is it a land use that's allowed under the ordinance? Now, one thing which I'm sure that you folks are going to have questions on has to do with your definition in the ordinance, because the definition includes a provision about licensing that's in the definition. I suggest that it's maybe a bit of a red herring. I don't want to use that. I know it's a strong term on the licensing, because frankly, if a license is required, it's going to be mandated. And if state law doesn't require a license, then it's not going to be required because the law allows for it. Either way, it doesn't change whether or not that's a convalescent home, because it will still be a facility that provides, as the applicant stated, therapy and facilities for the mentally disabled. Other portions of it we don't really have to worry about, whether it's farming. Everybody knows how the Right to Farm Act applies, whether it's grazing, orchards, or otherwise. If it's commercial, they have to meet GAMPs. If it's not commercial, it's a hobby farm that's generally allowed in your zoning ordinance in these districts. Most of that activity appears to be in the MAF district, although there does appear to be some orchard lands that go across into the PLS zoning district. So I really would like you guys to focus on the land use and not so much the disability, which everybody's made into the larger story, and we may get to where you need to go without having to do so. Still, it's important that you know about it and how the law applies to those who are seeking zoning permits and are otherwise protected because of their disability under federal law. I can give you an example, actually, where a federal case here is Cinnamon Hills Youth Crisis Center, Inc. versus St. George City, 685 F. 3rd, 917, 2012. Notice the court reporter here, that's why I'm giving you that boring information. But this was a case where the landowner prevailed, or I'm sorry, not where the landowner prevailed, where the ordinance prevailed, but the reasoning behind it is quite interesting, and I'm just going to read a synopsis here. Factually, it was an operator who sought a zoning variance to operate a residential treatment facility on the top floor of a motel that the operator owned. The city denied the variance. The Court of Appeals held that the operator failed to establish that the denial of the variance was due to disability discrimination. The operator argued that a provision of the city code that required residential treatment centers to be located in rural areas was facially discriminatory, but the city did not base its denial of the variance on that code provision. Instead, the city relied on a rule limiting motel stays to 29 days and a rule against residential uses in a commercial zone. The operator failed to establish a prima facie case because there was no evidence that any similarly situated non-disabled applicants had been or would have been granted the zoning relief that the operator was denied. A disparate impact claim failed because there was no evidence that disabled individuals were less able than non-disabled individuals to avail themselves of limited exceptions to the zoning rules. In other words, if the ordinance is treating everybody the same and it is not being denied because of the disability but because of the legitimate provision contained in the zoning ordinance, you're going to prevail. However, if it is being denied because of the purpose, or the sole purpose is because the facility is being operated and being utilized and occupied by people of a protected class, which the mentally disabled are, that's where you run afoul of federal law, and that's where, if you have, in fact, zoning provisions that target these groups, you would have to have the reasonable accommodation, thus the standards under the Federal Fair Housing Act and the ADA that I provided at the end of your findings of fact. I know that you received a lot of information during the public comment. We had one gentleman who I believe worked in a nursing facility who said, well, we believe that it can pose a safety hazard with these residents coming out and perhaps committing whatever outside the facilities if there's not proper security. On the other hand, you also had evidence of an individual who stated that he lived in a neighborhood where such a treatment facility was operated and he had no problems whatsoever. As a planning commission, the evidence that you have can be something more than a scintilla, but less than a preponderance of the evidence when you, as far as the support you have for the standards and findings that you make. But I'd suggest to you that if the planning commission simply said, well, we have this one gentleman, we said he had credentials here and stated that there's a danger, in having such a facility here. If you hang your hat on that alone, then you're hanging your hat precisely where the federal law prohibits you from doing so, because the sole basis for the reasoning for denying the permit is based upon the facility and the people who are occupying it in that protected class. So as you go through these findings, it's critical that you look at the land use first before you even think about who's occupying the land. Is the land use allowed? Do they meet the standards for the land use under the ordinance? If they do, there's no further analysis required to move forward and you make your decision. If they don't, then what is the reason why they do not meet those standards? And if the reason is based upon the protected class status, you're going to have a problem. Right? Federal litigation will probably be amended, and you're going to have some serious problems in the county will. But if it's like the Cinnamon Hills case here, where we can distinguish and say, wait a minute, part of this use or this cabin kind or whatever else wouldn't be allowed. It doesn't matter whether the people are disabled or not, because everybody in the same boat that you are wouldn't be allowed to have this cabin counting or this restaurant no matter what. Then you're in a safe area as far as a decision, or at least a safer area. No matter what you do, and no matter what your decision is, ultimately, there's going to be an appeal or the continuation of a lawsuit from either side. That shouldn't influence how you decide. I know it can be tough, it's stressful. It's the way it is sometimes, and that's why the counties put their trust in you folks, because they know you're able to make the tough decisions. So with that, I don't know if staff wants to add anything further from what I've provided. I can certainly take your questions. If you have questions of the applicant, they're here to answer them. And I know that you may have questions pertaining to the licensing. I know that was an issue for many of the Planning Commission members. Now is your time to ask and answer questions. I don't want you to feel pressured to absolutely come to a decision tonight. You may end up making a decision tonight and finishing this up. If we have to have one more meeting, I suggest that would be the last meeting in order to wrap this up. So with that, looks like Chuck already has his question.
Can you hear me?
I sure can.
You'll probably hear me without this, but my question is, you're indicating that if they propose a restaurant in the Lake and Stream, that we would have to look at it strictly as a restaurant, and whether that use is allowed in Lake and Stream. But what if what they're proposing doesn't really fit the definition of a restaurant? What if that is only an auxiliary use to the building? In other words, saying that it's a restaurant because there's food consumed there. There's food consumed in almost every building that there's a person in.
That's right. And I see exactly where you're going, Chuck. I think you're correct under that analysis. Is the primary use of that building a restaurant? There's been discussion that therapy is going to be held in that building. Now, I know that, and I've discussed it with Steve, that while there are other uses where therapy would also be allowed if it was a church or otherwise, but I think it's not an illegitimate question to say, well, wait a minute, if we're going to approve this, it's going to be a restaurant. The therapy use, which is part of the convalescent home use allowed in the MAF, is where that use is going. So you're correct. If it's a multi-purpose non-restaurant use, it doesn't matter whether a party's disabled or not disabled. It's based upon the land use itself.
Right. Now, I keep revolving back to what my first comments were last month, that this whole thing should be looked at as a unit. All the buildings are part of a facility to provide treatment or therapy to mentally impaired or addicted, substance abuse addicted persons. That's the use of the whole thing, the primary use of the whole thing. Now, if that's the primary function, that's what this thing is set up for. That's why they're asking for it.
That's where the problem comes in with the bifurcated zoning district.
But the whole thing is like a college campus. It could be across several different districts. It's still a college campus. There may be a swimming pool, there may be a stadium, there may be dormitories, there may be a restaurant, there may be a bookstore. You can look at each of those parts separately in the different zoning districts it may fall into. Mm-hmm. But it's part of a university. What's a university there for? It's for educational purposes.
Well,
all of those individual buildings may have a tighter use, but the primary use is still an educational facility. The swimming pool can be used for swimming. To say that it can or cannot be there based on the fact that you've got a pool is not really the question. The swimming in the swimming pool is an auxiliary use. The swimming pool is a part of the educational institution. A library, it may be for reading. But the library, as part of that whole, is really an educational function for research, providing information for the students to learn. It's not a library as the library here in town is. It's an auxiliary use to the educational main function of the university. A laboratory, a chemical laboratory. They may make, and I hate to say it, but when I was in school it wasn't illegal, we made explosives in the laboratory. Matter of fact, I gave some of them to my brother, and when he finally decided to get rid of them at his wife's insistence, the state police had to come with a bomb tank to get rid of it. And I hate to say further that I brought it back from Colorado School of Mines on an airplane. But that was all before all these restrictions took place. But a chem lab can be used to manufacture things. But it isn't a manufacturing facility. If it's part of the university, it could be if it was standalone someplace else. Its primary function is education.
And that's where, Chuck, it may push you then, if the Planning Commission says, well, we're going to decide that all these uses can only be stuck in the MAF district. The PLS, it's not really a restaurant because it's part and parcel of this entire facility. That's where the accommodation provisions then will have to be looked at by the Planning Commission.
Okay, so if you assume that it's a unit, and the primary function of that unit, and the reason the whole thing has been requested, is to provide treatment facilities for the mentally handicapped and the addicted people, then that's its primary function, its primary reason for being there.
Would that be
Anything
true of an
else would be-
outpatient facility? Let's say it's an outpatient facility. They live somewhere else. Is the living, or where you are occupying your residence, critical and part and parcel of an outpatient facility that otherwise provides everything else, including perhaps meals during the day? See, that's the problem we have here with that divided zoning district here. You have to have a primary use in that divided zoning district, in the PLS district. And you're right on one aspect. If the restaurant is being used for other uses that are not allowed in that PLS district, I think the Planning Commission has a right to say that's not allowed because it doesn't matter whether you're disabled or not. This restaurant use is strictly for a restaurant and not for treatment or any other of the facilities here. But unfortunately, under Michigan law, when we finish here, because you have that divided district, you have to have those primary uses related to that district, and that's what's being proposed and presented to you. If you reject it and say, "Oh, it's not," because I consider that part of this place as being an entire campus because there's farming activities, and perhaps the farming activities are related to the therapy. The overall atmosphere of the entire place is for therapeutic lifestyle purposes, and therefore the living cabin colony is only because of the therapy. That boils back down to, well, we have a cabin colony. Does it matter what the purpose is behind the cabin colony? What if the applicant said, well, we're going to have a cabin colony for the disabled here with a restaurant in the PLS district, and assuming this is allowed in the MAF district, I'm going to have a 7-Eleven, right on Grandview Beach, or Grandview, whatever the name of the road is, Grandview Beach Road. Well, then you'd say, well, this 7-Eleven has nothing to do with the cabin colony or the restaurant they have there, even though perhaps some of those residents would walk over to the 7-Eleven to get a slushie and walk away. This is the issue because of the divided boundary line between those two uses there. I think you're going to have a tougher time fending off legally a challenge if the Planning Commission rules that we're going to allow all this in the MAF district. It's certainly better than a denial based upon the disability or on the activity there. We're going to allow this all in the MAF district, but because your use is part and parcel of an overall therapy use, which is related to the purpose behind a convalescent home, we're not going to have the cabin colony and the restaurant located in the PLS district. Well, the argument is going to be in federal court. Well, Judge, the reason that we didn't allow the cabin colony, or we didn't allow the cabin colony in the PLS district, is because of the disability and the fact that they were getting therapy in the MAF district. So it's difficult. I agree. It's a difficult decision. But I think have to look at the land use, you got to pick them apart based upon what the applicant and the application has provided to you in each district. And you do, you have, now let staff jump in on this, but this is an application for specific uses in the PLS district and an application for some specific uses in the MIF district.
Yeah, I was agree. I think as some of the correspondence that we had in the different stages of review. Yeah, I would agree. If you look at some of the correspondence that took place in the early stages of the application, you'll see our efforts to render something down to that effect and get uses identified that were proposed in each zoning district. So I would agree with that. But I think at this point I would reserve any other comments as we specifically talk about each of the standards you guys have to review.
Go ahead, Chuck.
I still think we've got to look at, if you want to do it that way, we have to look at each of the component parts then and see whether that is really what they're being used for.
Yeah, I agree. I mean, you're looking at a restaurant and it's not being used as a restaurant. It's being used for something that's not allowed in the district. I think that's a legitimate review on the part of the Planning Commission. I don't disagree with that.
Okay.
Yeah, thank you very much. My first comment is this would have been tremendously helpful maybe a month ago at our first meeting. We didn't receive much of this other than to do your best and look at things. So this kind of more depth and detail I think is very helpful. The other thing was you get a little confused with this licensing like you talked about before, because on one hand I've read in all of this information, and forgive me if I get something wrong here, there are only about 1,700 pages or so of material, but it was to my understanding at first, at least, that the Heritage Farm is not going to be licensed and stated as such, and then later on I read that they would conform, if they had to any of the existing laws and things that come up. It is important for us to sort of probe into this licensing, because to me, and you can help me with this, I think it has a bearing on some of the questions that get asked when you start to ask. People are very concerned about the safety. People are very concerned about the property values. People are very concerned. And the licensing has a somewhat, it has an effect on how that decision might be made, because licensing at least gives you some structure around which people can be reassured, or that the facility could exist and people would be screened properly. People would be under some kind of a requirements that would be set upon them by the state. And so it helps answer those questions more to the affirmative than if you don't know what's going to happen and you're sort of say, okay, would the property values go down? Well, it's possible they would. If there was an incident on there, that might lead to that. So that's my question.
Okay. I mean, I think it's legitimate to ask questions about the licensing, because it pertains to the type of therapy that is ongoing on the property, which I'm a little hazy about, and perhaps the PC and staff remain a little hazy about. I'm not so sure about the property value, because none of the evidence presented was from a certified real estate appraisal that said, yep, this type of use will result in a definitive drop in property values, and therefore that evidence may not even approach this until it's fairly speculative. It's not an uncommon request or a statement when someone's applying for a special use permit, regardless of the use, saying that I think this use is going to result in a drop in my property values. But I don't recall, maybe the staff can correct me, that we didn't receive any appraisals or anything of that nature related to the drop in the property values. But the questions regarding licensing, yeah, I think that's absolutely on target. Go ahead.
Okay, me again.
That's fine. I expected you all the way through.
We had a case back 5-6 years ago down in Linda Township. A similar facility was proposed.
Mm-hmm.
We did get input on real estate values on that, based on the fact that the people that applied for the license or the special use permit had another facility downstate, which was on a lake in amongst a couple of subdivisions. The facility was approved, and they did provide information at that point that there was no change in the real estate values.
Oh, okay.
So that, to me, is the closest thing I know of personally to anything that would substantiate or refute the increase or decrease in real estate values.
And you're right. I mean, sometimes you will get cases where there's going to be, a study done or appraisals that's done typically now when you got something controversial like a wind farm, for example. I actually sat on the other side of a municipality for the first time about 3 years ago, not successfully representing a citizen group against the Lake Winds Energy wind farming down in Mason County. And we did pull up, all that information. We got the experts. A lot of money was spent on that. But, Consumers Energy also had lots of money and lots of experts, so it didn't quite go our...
Just like lawyers, there's always two sides.
So, but going back to the to the licensing and perhaps some haziness on the part of the PC as to what the therapy uses, that fire away those questions.
That's one of my points here.
Yep.
I don't have personally enough information here that's been provided by the applicant or anybody else that tells me exactly what they're going to provide in the way of therapy, exactly who's going to provide it, exactly what their qualifications are or are not, and then what would be required by the state for the various types of treatment or therapy that might or might not be required for a license.
And
that information has not been provided to me, and I don't feel it's my responsibility to go out and hire somebody to dig into that.
No, but you can ask away and ask why. And just getting back to what John had mentioned earlier, the reason I didn't get into the depth at the last meeting that we're doing right now is because the last meeting was mainly for the large audience and the public hearing. We wanted to get through that. I don't want to hinder your time here. I don't want you to feel that you're pressured time-wise at this meeting. This meeting is about having the ability of planning commission members to ask these questions and to move forward and pick apart the findings. I don't think you should feel pressure that you have to absolutely get it all done tonight. The best effort should be made.
Sure, I think my comment was not to make anybody feel bad. It was just simply by bringing out this information, it can change the way we look at things and the quality of discussion and questions we may ask. Like you raised some comments here where I would have asked several different questions of that group based upon what you said, because my thinking at that time was a little bit differently than exactly what you said. I just wanted to say one other thing. There was some data presented to us by one of the property owners who said that they had a sale on their property that was withdrawn and is now pending because the people say they want to find out if this is going through. I don't know what the end outcome of that will be, but that is some anecdotal type data.
I guess I have to go back a little bit. I was surprised at the findings. When I looked at those, I just shuddered. I said, man, after all the input we got from the public, the testimony and so on, I didn't see anything in there that related to safety, property values, medications, any of the things that people spoke about. There were several locations that some of these will not supports would have been. I think if you have 30 people that drive here and testify and say they think there's a safety issue because of what happened somewhere else, at least the finding could have said, at the public hearing, 25 people testified that safety was a main concern. Whether they prove that or not, we have an old study that someone brought up here that's old, and we don't know what really happened there. So I think in some cases, I think there was room for, on both sides, will support and will not support. And I think no one in the audience, we had some medical people that have been around for a long time. We had a policeman that was in service for a long time. We had a lot of people with knowledge on similar institutions and projects. And, their information should be valuable. And when do we decide if that's a finding or not? I think that there's not one thing that anybody brought up at that public hearing that everybody showed up for that's in these findings. And I think that even if we have a large number of people that say safety is an issue, or they have a sale pending, or they think they can't use their property like they used to be able to use it if they had this cabin colony or whatever there, I think those should be included in findings, even if it says 15 people spoke as to the use of their property as something that we could consider. Because I think, they will believe that they've wasted their time talking to us. What good did it do them? Did we use any of it? And looking at these findings, we really didn't. So that's one of my comments. And this is my first crack at the mic here. Is it correct to ask the applicant questions regarding the licensing, the type of therapy? Do we ask you that? How do we get to that point where we find out licensing is a big issue to many of us? We wonder why the applicant is not totally interested in getting whatever licenses may be necessary. I know if I were to open a business, a restaurant, or go into well drilling, the first thing I would look at was what licenses I need, what kind of insurance I need, and so on. And that is a very vague, the information we have is very vague. And I think licensing and oversight of a project, no matter what type it is important to anyone.
Well, first of all, you can go ahead. Those questions really should be of the applicant. Your staff was pretty diligent because they actually tried to investigate that on their own. And I'll let either Scott or Steve speak to that. The bottom line is that staff was unable to come up with a definitive answer from any of these state agencies because they said that they needed additional facts other than what was on hand and what was provided to the county. So perhaps part of your questioning of the applicant may flesh that out a little bit more. As far as adding some of the public comment, we certainly can add that directly into the findings of fact. As I said in the beginning, you can delete them, you can add to them, just make sure it's related to the evidence on the record. The only thing I'm concerned about is if the denial is based upon comments related to the disability of the occupants of the property, I think we're going to have a problem. And that's my main concern. With that, I don't know if you want to talk to me anymore or you want to start talking to the applicant.
Yeah.
I got questions for you.
Okay.
I've got a couple of comments I'd like to throw in here.
Okay.
Number one, the minutes of the last meeting are rather all-inclusive, throwing all the public comments in, and they're in the record, and it is part of the official record. So all that is in there, whether it's brought out in the actual summary of findings. It really doesn't make that much difference. It's considered, it's in there.
You can have a court report.
That's right. The other thing is a safety issue, and I had originally been looking at the safety issue from the standpoint of somebody walking off reservation and causing some problems. But in view of what's happened today in California, there's a safety issue from the other way. There's a facility similar to this out there that 2 or more gunmen walk into, and they killed 15 or so people and wounded 15 more, all in a mentally handicapped facility. So there's a safety issue, obviously, from that standpoint. It may not come up very often, but if it just come up, and it could very well be an issue.
Thank you. Thanks for being here, Council. I have a question. I've been really confused about the Federal Fair Housing Amendment Act and how it applies to zoning, and what does that do? How does that come into the mix here? What should we be thinking about regarding that in our zoning?
Mainly, it does the application of the zoning ordinance result in discrimination against people who are in a protected class, such as those with a mental disability. So, for example, if you're saying, no, we're not going to, let's say, I guess I'll go back to the cabin colony. And if the denial of the cabin colony is because of the safety question, we don't believe that because there's adequate licensing or adequate staffing, that the residents would potentially pose a threat, and therefore you're going to deny the cabin colony based upon really the status of them as a protected class, that's where you're going to have a problem under federal law. If the application of the zoning ordinance is not discriminatory, okay, and is such that it would apply to all parties across the spectrum, regardless of whether they're disabled or not, unless there's other issues like exclusionary zoning or something of that nature, then you're going to have more of a defense, so to speak, and not so much a requirement for accommodation. Now, there are other disabilities that require an accommodation regardless of the application of the ordinance across the board. A land use example would be, let's say, a steep slope on a cottage, all right, going down to the waterfront, parties in a wheelchair. Ordinance doesn't allow for more than a 15-foot wide path, through the vegetation strip to get down to the waterfront. In order to, for the person who's disabled and occupying that property in a wheelchair to get to the waterfront, which is a reasonable incident and reasonable to reasonably enjoy their property, you're going to have to make an exception and allow them perhaps to excavate to create either a switchback or a direct ramp that will adequately provide space for a wheelchair to safely traverse the back end or the steep slope of the property and go down to the water's edge. This is one of the first cases I actually dealt with the ADA, and it was for Otsego County back about 16 years ago. And that was exactly what that fact pattern was. And it was not an easy sell to a very angry ZBA. But the judge then, it was appealed, and the judge agreed with the ZBA, saying that's exactly why that variance was required, is because otherwise, without excavating a wider area in order to properly slope the land to allow for access, this person, but for their disability, was unable to enjoy the same privileges and benefits of those without a disability. So that's the line you're traversing. Are you denying it in such a way that they are unable to benefit and enjoy their property or the use of the property in the same manner as people that are otherwise would not be disabled?
We have residential units. Let's just look at them as that.
Sure.
Proposed in both districts.
Mm-hmm.
In one of the districts, if you call them a cabin colony, they're authorized. In the other one, a cabin colony is not authorized. So they're either one thing or they're the other. And they're authorized in one place or they're not in the other. So, how do you circumvent the fact that there's something to live in? If you want to get down to that far and say that, okay, it isn't really a cabin colony, but there's housing units there that somebody's living in, and therefore they should be allowed. But we wouldn't allow it otherwise for anybody in one of those districts.
That's in the MAF district.
That's right.
Yeah. Then the question is, do you accept the fact that those housing units, albeit cabins in the MAF district, are part of the therapy use that would occur on that property?
But if you're going to do that, why wouldn't you look at the other side the same way? Why can you discriminate in the way you look at it, forgetting about what you call it? The use is the use, and the use is the same on one side as it is on the other. If you're not going to allow it, and you can disallow it on one side, then you should be able to disallow it on the other side, regardless. The use is the same. It's exactly the same use. They're the same type of units.
Oh, they're the same type of units. There's no doubt about that. The problem you have is you have two separate zoning districts.
But on both sides, those units are going to be used only for those disabled individuals.
That's
They're
correct.
not open to the general public. I couldn't go over there and reserve one of them. on either side of the line for any reason.
And if it was a private club, you wouldn't be able to do that either.
That's correct.
The question is, and I think this is the real point, it isn't a difficult question, is the housing that's in the MAF district, being the cabins, which they don't allow cabin colonies in that district, do you treat it as a part and parcel of the convalescent home use?
That's exactly what I'm saying.
Mm-hmm.
And if you treat it that way on one side of the line, you should treat it the same way on the other side of the line.
No,
They're the same units.
or you could ask for a conditional rezoning.
You could ask for a
Right.
conditional rezoning.
You've been through that.
The whole thing could have been treated as a conditional rezoning.
I mean, that's the tough decision that you guys are going to have to make here, all right? But, you know, as I said before, under Michigan law, if you have a property, even though it's bisected by two separate zoning districts, you have to look at what are the primary uses in each of those districts, even if there's a crossover.
But what I'm saying is the cabin colony or the cabins, the cabin clusters, the use is the same on both sides of that line.
That's right, it's residential.
That's right. And if you authorize them on one side because they're part of a convalescent home, then you should be looking at it the same way because it's for the same purpose, the same use on the other side of the line.
That's great, and let's assume that is, because we know it is. Where in the PLS district does it state that you have to have a specific reason behind the use of the cabin colony?
No, but the use is different than a normal cabin colony.
Why is it? What's being used for? What's different?
It's being used for the residents for the mentally disabled individuals only.
So if it wasn't being used for mentally disabled residents only, it was being used by the VFW post, for example, then it would be allowed, but you don't want to allow it because it's used for the mentally disabled persons who will be otherwise using the property. That's the problem. That I'm playing devil's advocate here, Chuck. I understand where you're coming from here. I just want you to be aware of some of the perils in the law behind the decision making. And that's where you have that mixture of that federal law and also the state law, where you have to take a look at each zoning district separately, even though we darn well know that there's a crossover going on here as far as the overall use of that property. Sure.
If I'm trying to think logically about this, what you would like, or what your advice is that I consider it something other than a mental facility and decide whether I would allow that activity or not. For me, I'm thinking of a camp. Okay, if you have I'm going to relate to a church camp because I've been there. And if I have a building that has a food facility, plus it has other rooms that we could go and we made crafts, or we had counseling, therapy of some sort, and then we had cabins that were used. So if I were to allow that here, then I basically would have to allow it if it were any other use, right? I mean, is that what you're saying?
Yes, I mean, in part. If let's take away the mental illness factor and the treatment related mental illness. Let's just say it's an R&R could be a retreat.
Yeah.
Okay, let's say it's a retreat, and the retreat provides meals. All right, and they provide, and they happen to have the meals in the PLS district, and they happen to have the retreat housing. Well, you got to look at what your zoning district allows here. Let's start with the MAF here, because you have a variety of special land uses here. And I don't want to deviate too far from the convalescent home use which is being applied here, because otherwise I don't think we get into 9.3.22 uses that are not expressly authorized, because if it's convalescent in the MAF, it's also allowed in multiple other districts there, so we can't really use that section of the ordinance. If you're going to say it's something else, and that something else is not otherwise authorized in the district in MAF, then you can use that 9.3.22. But what else do you have? Although it's not, this is by special use, and this is not what is being applied for, but you're right, you have churches and parish houses. Well, that could be a church retreat, okay, as an example. Community buildings, public parks, recreation area, playgrounds, campgrounds, entertainment and eating establishments, commercial hunting and fishing cabins, golf courses, country clubs, sportsmen associations, or clubs, grocery and party stores, resorts, resort hotels. But if it's a resort, if you have a resort, you probably have a bunch of cabins, lodges, motor inns, motels, tourist lodging facilities, slaughterhouses, meat packing, travel trailer ports, public airports, non-essential public utility buildings, nursing or convalescent homes, feedlots, piggeries, a variety of uses here. But the applicant is asking an MAF is for a nursing, basically a camp, a convalescent home. So what are the accessory uses for a convalescent home, regardless of the occupants of the convalescent home in that area? Does it include housing? Where in the ordinance it includes housing, would it restrict that housing to a single building as opposed to cabins in there? Is it true that there's going to be carryover in the PLS district for those cabins because they're going to be crossing over and using facilities in the MAF? Yeah, that's true. It's absolutely true. Let's take a look then at the PLS. Cabin colonies, 10.3.3. I'm trying to find here, under a supplemental or requirement, if there's anything that's in the ordinance that says, well, your cabin colony can't be used if you're using facilities that are related to the property in another zoning district on the same property. In other words, does it really matter, or does the ordinance regulate why you have the cabin colony there? And I suggest to you, again, staff can yell at me if I'm wrong, I don't see where in the ordinance it says that you have to have a specific reason as to why you want the cabin colony or why you want to have the restaurant that's allowed. I do agree, going back to Chuck's original comments, that if it's not being used as a restaurant and that it's being used for a purpose that is not allowed by special use in the zoning district, then it doesn't really matter whether the party's using it or disabled, part of a retreat or whatever else. It's not going to be allowed. Chuck, go ahead.
Okay, first of all, our regulation fails in many regards. One of them is definitions. The term cabin colony is used in a couple of places,
Sure.
but it's never defined.
Oh, cabins are, but not
Cabins are, but cabin colony is not.
That's right.
Therefore, you've got whatever our usage has been of that terminology determines what it really is. And I can tell you what it's been used for and what we've authorized cabin colonies for. And I can give you we can dig out the cases easily that show what they've been used for. And they haven't been used for semi-permanent residences for anything. I've got what I came up with is what we used as a definition. A cabin colony is a group of cabins available to the general public on an individual basis for recreational purposes, for rent, for short or intermediate periods of time. The applicant's proposing these cabins be used as residence for longer periods of time for the mentally handicapped individuals or staff. Staff will probably even be longer than what I consider a long period of time. So the cabin colonies, as they're proposing to use them, don't fit most of that definition other than as a residence for some period of time. They're not available to the general public. They're not available for rent. The period of time is longer than short to intermediate. They're available for staff for a semi-permanent residence. So where are we able to draw the line and say that their cabin colony isn't really a cabin colony?
Well, I mean, what you came up with would be a great suggestion to staff to amend the zoning ordinance, but I don't think it's something
Don't
you can
go there
apply.
because I've already tried that.
But unfortunately, I don't think under the law you would be able to apply facts based upon past cabin colonies when that term is otherwise undefined in the ordinance.
Well,
The only thing you can hang your hat on are the cabins, and that you know what it means as far as what a cabin is concerned. where the applicant may run afoul, and probably the reason that they went toward the cabin colonies is if you have duplexes or single-family structures, then they're not going to meet the density there. Okay,
That's
criteria.
another one of my points. If this thing was accepted the way it is, it still isn't legal. There's a number, as I see it, and I happen to be on the ZBA also, they'd have to come in for a number of variances before they could even go ahead with what is proposed here. Now, if it's
Like what?
density,
Not on the cabin. I'm going to let this is more of a staff because these guys have been digging into it more than me. So I'm going to. Scott, I think you can use that microphone right there.
it depends on which side of the line it's on.
Yeah. Okay. Yeah, the application is for cabin colony. They also mentioned in the application multifamily residence duplexes, and I think when you evaluate those uses, those density standards apply. They would not apply with regards to cabin colonies, in my opinion, because they're not dwellings, they're not residents, and all of those standards are relative to a per dwelling standard.
Right.
So when it comes to the cabin colony, those density issues.
But that's only one side of the line.
Yeah, the other side of the line, you're asking for convalescent home, and there's no such standard there either. So I would say those wouldn't apply in this case.
How about the use of the property to the water? Access. Multiple dwellings, access to the water.
Well, if you were considering multiple dwelling use, then I would say yes, but you're not. You're considering the cabin colony, where they don't apply.
You don't
Because
feel that
they're not defined as dwellings.
how about the cabin colonies?
Cabin.
On the other side of the line.
That's what I would think you'd have to consider under the convalescent home use that's being requested.
On the lake and stream?
In Ag Forest, that's what you're referring to, right?
Well, yeah, one way, and then the other way is the lake and stream.
Yeah, then you need to consider those as cabin colony because that's what's in the application.
Not dwellings.
Correct.
I have a hard time with what they say they're going to use them for is them not being dwellings.
Well, I believe you're going to have to evaluate that request.
They've got kitchen facilities, they've got sleeping facilities, they've got everything in them for a dwelling.
Well, that raises a point there because it was mentioned with the kitchen facility, which carries it over out. That's why the definition of cabin is important. That was not what was originally, provided in the application.
But it was brought out in the testimony last
I agree.
month.
So that's part of the questioning that you're going to have here.
Right. That's going to be part of your evaluation of that proposed use.
Can we use cabin as part of the definition for cabin colony? Is there a way to, do you hang your hat on cabin as the first portion of that term?
Absolutely. Because if it's a cabin, it has to meet the definition of cabin. Yep.
That's building, tent, similar structure, sleeping quarters for transients or for temporary residents, not to include hotels, lodges, houses, or tourist homes. So you're saying we could use that portion of it because there's a definition. We can't use cabin colony because there's not a good definition.
Correct.
Thank you.
Yes. Now, and this gets back to Chuck because he's concerned about how long, residents will be there. So what constitutes temporary? I don't know if you have any, don't have anything in the ordinance on that either, I don't think.
Nope.
So temporary is something less than permanent, I guess, and the applicant's represented that it's not permanent.
I'm not sure of this because we start talking about reasonable accommodation a little bit after some other things get worked out. But the confusion, a lot of this gets concerned, obviously, because we've got these two different zones and the uses in each one are slightly different. Is it possible, as we proceed through this, and you may suggest that a reasonable accommodation be that the proposal be changed such that all of the materials, let's say, or some substantial number fall in the ag forestry, and then the things become, all the other stuff becomes an ancillary use to that?
Well, I think one of those areas, perhaps, is the therapy use in of itself. That's precisely correct there, because therapy, I mean, we all know that convalescent homes provide therapy, right? And we know that convalescent home and the therapy component is not in the PLS district. I think staff has kind of gone back and forth on that because some churches may have a therapy component and so forth, but that's not what's being asked for here as a church. So that's one example where I think you're correct.
Question for Scott. When you had your preliminary work on this proposal, did you look at other options? It just seems like we're spending a lot of time on an option that has all these questions and stuff. Was there any suggestion to maybe include most of this in forestry ag, use convalescent homes in that program, and then possibly look at accommodation or some restrictions in that zone? It just seems like, we kind of went around in a circle here, and I guess that's a question for the applicant. If as with licensing, and I think if we have time, is that time we could ask that? And my question, did you go over all the other options for proposing this kind of a project? Because they do have forestry ag. There's a lot of uses that they could use as primary in a forestry ag zone that they couldn't in lake and stream.
Yeah, I believe that at different times other options were discussed, use variances, conditional rezoning, locating in other areas, things like that, during the several different times that this was being contemplated, sure.
Okay, maybe an applicant's not here. Is there a representative regarding licensing? We'll wait until he gets back. But I'd like to ask some questions on licensing.
Hi, I'm Susan Babcock. I'm the attorney for the applicant, and I can answer any questions that you would like.
Okay, my question is, as we talked earlier, most people look at appropriate licensing, regulations, insurances before they ever start a project. Is there some main reason that there is not an interest in being licensed, which there would be some oversight by some agency as far as the clients coming in, screening, the people providing the services, the type of medical people they may have, those kinds of things? I'm wondering why that wasn't an upfront discussion on licensing. There's got to be institutions that are licensed. Can this one be licensed? Should it be licensed? What requires a license? I think that would clear up a lot of the questions we have regarding safety issues and oversight and all those things. And I was surprised when that question wasn't one of the first ones that was brought up and discussed on the exact licenses that you may try to get for that project.
Sure, and I'm happy to address this and hopefully alleviate anyone's confusion regarding the licensing issue. And with this being said on the record, hopefully it will clarify it as much as anyone needs it to be. The applicant does intend to get any and all licenses that it is required to get through the state of Michigan. Part of the issue of why this sounds so circular, and it's similar to what we're all dealing with in analyzing the overall property, is because of the type of property that we're dealing with. We've been in discussions with the state of Michigan, but up until the project is approved and more details related to the actual business plan are flushed out, we do not have specific direction from the state of Michigan yet as to which licenses we will need, how many we will need, etc. But any and all licenses that the state of Michigan requires the applicant to get, they will be had, and that's something that my understanding is, can be placed directly into the SLUP, is that there's a condition that we obtain any and all licenses required.
Yes, I mean, that's a requirement of the ordinance, and if the application, the special use is approved, that would likely be a condition. It's one that I suggested anyhow.
Did you have anything further?
I think that helps. I'm just wondering what difference it makes, what type of property you own regarding the license. I mean, somebody should be able to say, hey, for 1 through 24, on such and such clients we're going to have, you need a type 2B license. I mean, there should be something out there that says what you need. I happen to work with the health department, and if you want a food license, there are different categories. If you're, a church is one, or if you're a full-time restaurant, if you serve liquor. So all those options are available to anyone that would want to open a food service. They would know exactly what licenses may be necessary. And I'm just wondering if that's been looked into. The type of property shouldn't really make a difference to the state on licensing. It's the use, I think, and the therapy used, and number of clients, and those kinds of things. But thank you for your input.
Sure. Betsy is able to discuss with you, if you'd like, more about her discussions with the state of Michigan as to licensure and why, at this point, without an approval, there wouldn't be, this is too early to obtain licenses. This is not something that would be obtained at this stage, other than saying that we will obtain a license as needed. And then Betsy can discuss with you further exactly their discussion.
Thank you. I sat down with the state of Michigan to discuss this project before it even came to you. And if I can just correct the record, I have neither has the application ever stated that we have no interest in obtaining licensing. So I realize that may be just your interpretation of something, and it clearly was stated by certainly other people in their public statements. That never came from the applicant. So I'd just like to set that record straight. As I said, I did sit down and meet with the state of Michigan before we even submitted our application. The first thing that was made clear to me is we cannot submit an application to the state of Michigan until we can provide them with zoning approval. So that's why this is step one as far as the state of Michigan is concerned. However, I went through with them what our plans were and what we intended to do, how many we intended to serve. And it appeared to them that what we would probably be classified under is a medium to large adult foster care. Now, to the extent that we have an interest in doing additional things like group therapy and individual therapy, the persons providing those therapeutic services are required to be licensed. And that is a totally different licensing than the licensing for the adult foster care. So if that helps you in any way.
Yeah, I think it does.
Okay.
So they're calling it an adult foster care.
Correct. And that is what.
No, it's the first we've heard that.
Yeah,
so
we
have. Well, I think I said it in the public meeting last time, because that's and I refer to it as Rose Hill, because we've been using Rose Hill, which is down in Holly, and that's the same type of licensing they've received. Now, there are two different things, licensing and accreditation, which quite frankly, we would probably be looking for different accreditation, which is far superior and difficult than just licensing of adult foster care. But the accreditation is voluntary.
That's just the first time we've heard that term, adult foster care, in this project, or that maybe we missed it. But
I remember the conversation that you had with us telling us that you can't get licensing approval until you get zoning approval. I do recall that conversation.
You've been, this is maybe for the orders of the attorney. You've been involved with these different discussions. Could you help us some with why it is you would like to locate in the two different zoning areas? Is there overriding reasons why that would benefit?
Sorry, I turned this off. Can you hear me? Okay. There's a few, and I hope to not be long-winded and convoluted, so I'll try to address it as quickly as possible. Part of it is that per your zoning ordinance, both districts are buildable property. There's nothing in the zoning ordinance that prohibits you from building in PLS or in ag. They are both buildable. The other part of this is that they are both usable as residences for non-disabled people. What that means is that according to Michigan law, if a non-disabled person is permitted to live somewhere by right, then a disabled person, given accommodation, should be permitted to live there as well. So we are doing our best to work with your zoning ordinance, which provides non-disabled people the right to live in PLS and to live in the ag district. So we do have residences in both, but that is in compliance with your zoning ordinance, which permits residences for the non-disabled. Additionally, as far as something that your attorney mentioned that I think might alleviate some confusion as well is our primary use, is described as a residential therapeutic farm community. And obviously, that's not a use that falls within anyone's zoning ordinances at this point. But if you break that down, the primary use is a residential use. We have residential uses in PLS, and we have a residential use in the ag district. Anything else in addition to that residential use are ancillary uses that involve this disability. So for example, the residential use that is in the PLS district, those are cabin colonies. There are not full kitchens in those cabin colonies. That is why we need a dining hall. The dining hall is something that anybody who was non-disabled would be permitted to have their own kitchen. Due to the disability here, we do have a group dining experience versus individual kitchens for that area. As far as the residences that are in your ag district, residences are permitted. They're permitted in your ordinance in multiple different ways. So they are permitted as family dwellings, but they are also permitted as convalescent homes. So one option we gave you here is to say, hey, this is analogous to a convalescent home because we are caring for the infirm who are living there as a temporary residence, and again, they do need a group dining hall. Due to the type of property this is and the layout of the property and the fact that there's already an existing house, we only need one dining hall. We don't need one, 500 feet away. So there is only one dining hall overall for the overall property, but regardless, the residences on both sides do need a place to have meals. Did that address your question?
Well, I have to think, are you saying that some of are you saying that some of the facilities that are, let's say, in the lake and stream area, those are let's say, primary areas that you're going to be using, and that there was no consideration as to whether you might do those in let's say, the ag forest area?
I'm not positive I understand the question. Part of it is that there is an existing home there. It is where the applicant currently lives, and that's what they are planning to convert to the dining hall to make use of the current existing home. The other huge part of this is based on open space. They're trying to take down as few trees as possible and use the existing buildable open space without taking down the trees. The engineers also looked at all their setback requirements and the distance between the neighbors. So these residences are a good distance from both neighbors. So the Hansons here did the best to fit these homes within your zoning ordinance.
Thank you.
Does our civil council have any comments regarding her comments? As far as what they're looking at there, if they understand that it could have, if they proposed it forestry ag, it would have been somewhat different. 100 foot.
Yeah, that's all I have.
Yeah, for 100 foot over we wouldn't be with in this situation where we have all these concerns and accommodations, possibilities for 100 feet, could have been proposed in that district. And I think that's what John was alluding to. But I'm just wondering if you had a comment regarding her statements.
Well, I mean, say residents were using the restaurant, whether they're on the same property in a different zoning district or on a neighboring property in a different zoning district, they'd still be using the restaurant. Okay, so I don't want to get too bogged down on the restaurant use. The only newer issue that I think is been raised, and that's part of what staff has been working on, really has to do with how do you handle the density issue. That's the reason why the residential use in the form of duplexes or regular residence in the PLS district for the density as proposed would not work under the zoning ordinance as it exists. You're stuck with cabin colonies if you're going to get anywhere as far as that's concerned. Then you have it on the other side here, and that's where the cabin colony is not allowed. The only way, and that's basically how it's been couched by the applicant, to have that residential use there is along with the convalescent home use and the convalescent uses that are being proposed for the MAF district. Now, the applicant is asking for a therapy use all the way across both districts. You may not be obligated to provide that therapy use across both districts, because if it's restricted to the convalescent use in the MAF district, then they still have reasonable use of their property and are able to conduct all those convalescent and therapy activities on that portion of the property. Again, because you have two separate zoning districts, you have to still have the primary uses, even though they're crossover. Because even though people will cross over from one district to the other, like I said with a restaurant, it doesn't matter where they come from to go ahead and eat at the restaurant or cafeteria. So, but with the residences on the MAF district, the only way that would work is with convalescent home use. So if you allow therapy in the PLS district, it kind of throws a bomb on the residential use for convalescent home in the MAF, because then that's where you have to, where the line probably has to be drawn in that scenario, and where a line drawn in that scenario would not violate the Federal Fair Housing Act, the ADA. I forgot the Michigan. The one Michigan Act which really is not as applicable.
Civil rights?
Yeah, the civil, because that has to do more with sales and regulates realtors more than anything else.
So you're talking restaurant density and therapeutic use on both sides. Is a little difference of opinion that you have?
There's a difference. I think the restaurant use doesn't matter where the people come from to use the restaurant. Okay, rather it has to do with where it's located, and therefore it doesn't matter whether there's a crossover. The residential use is. You're going to have residential use related to the therapy in the MAF district. That's how it has to be tied into. If you sit there and say, well, then we're just going to have therapy everywhere, then you're throwing away these other standards, and that's where you run into the problem with the ordinance. If somebody appealed an approval where you approve therapy on both sides, meaning MAF and PLS. Staff, I think, has a little bit of disagreement with me on that, thinking that such therapy could also be typically done with churches in the PLS district. But I would think legally that if you said, well, we're going to allow the convalescent home in the residential portion of it, which includes the cabins in the MAF, we're going to allow the cabin colony in the PLS, but you're not going to have therapy in the PLS, I don't think legally that there would be a very high rate of success on the part of the applicant if they challenge the denial of therapy in the PLS district when that use is already provided in the MAF.
That's exactly what I was getting back to. If you treat it as the same on both sides, you got a problem.
Yeah. And that's why you have a distinction here. And that distinction, I think, clearly is the therapy use that goes along with the convalescent home. Because I don't think there's an argument that therapy is not a part and parcel of convalescent type of facility. It is.
It is. There's no question about that. There would be no question about if those dwelling units were moved 100 feet over. There'd be no question about those. They'd be part of the convalescent home.
But you still have a question about people who are in a convalescent home, where they reside. Does it have to be in one building, or can it be in multiple structures?
You can move the
Does it?
cluster of cabins across the line, then they become part of that convalescent home.
Okay. The question is though, does a convalescent home, let's break it apart. Does a convalescent home have a residential component to it?
Yes.
Okay. Where in the ordinance does it state that residential component must be in one structure?
Nowhere.
Okay. And if it's and I guess then it boils down then to a density issue, which I'll leave up to Steve and Scott. But if it's part of a convalescent home, under the ordinance, would those living arrangements and those cabins be allowed in the NAF district?
Yes.
Okay. Well then, I think the breakdown is still there.
But what you're saying is we can make the distinction for the therapeutic treatment. On the other side of the line, if those cabins stay in the Lake and Stream Protection District.
Yeah, just like you're crossing over to go use a restaurant, you want to use therapy, you cross over to the other district and use.
So as a condition of the approval, if we approved it that way, we could say that there was to be no convalescent or no treatment or therapy treatment in those cabins that are listed on the
not just in the cabins, on the PLS property.
On the PLS.
I think Steve may have
if I could just clarify the density in the, it's mostly lot width. So if you start looking at this as the duplex multifamily use, which they're requesting in the Lake and Stream zoning district, the struggle would be with the zoning ordinance would be the lot width of the property. You have X number of residences on Lake and Stream. I mean, because of the shape of this property, the lot width is defined as a measurement average between the parallel side lot lines. So as wide as that is with 1,600 feet of waterfront, you have only 600 and some, I think, right, Scott?
That's correct.
Of lot width measured the way the ordinance requires. So it's really a density, a lot width issue with residential uses, not with catacomb.
That's one of the things I said would have to come back as a request for a variance.
Steve?
Yeah, and I think as far as that goes, then it comes down to deny it. It's either variance or the reasonable accommodation request that they have. Is that related to their disability? I don't know. If I could, well, I've got the mic. I'll be brief. As far as therapy, staff is in agreement with you when you were talking about that before. I think our analogy to a camper church would only come to the point where if you got to the point where you're going to deny it and you look at a reasonable accommodation consideration, then does this put an administrative burden on the county? That would be something we look at. Otherwise, we're in agreement.
Thinking's always good. Again, I don't want to make the planning commission feel rushed about this. I want you to settle in so that when you're ready to go ahead and deliberate, we have a purpose and an understanding of where we're heading. And that may require, to make some changes in some of these findings if you feel they're necessary. We just want to make sure that it's smooth all the way through as continuity makes sense. That's all.
I got a question on patients. Change the tone here a little bit. Is there going to be doctors on staff? Who's going to check these patients out when they come in if they qualify for this particular farm?
There will be licensed medical professionals on staff. I know that's something that was brought up for a moment at the last hearing of would Betsy be the one that was primarily providing care. Betsy is not a licensed medical professional. She does not intend to run the facility solely by herself. There will be fully qualified and fully licensed medical professionals at this facility, and they will be the ones overseeing the care of the residents.
And how do these patients find out about this particular place? I mean, they can come from anywhere, I guess. If it's, from Puerto Rico or wherever, it wouldn't matter. How do they find out the names of these places where they might want to go?
I think that's a better question for Betsy. I mean, my initial response is I kind of think it's an organic grassroots type response, just like how people find Rose Hill Center or Gould Farm. A lot of them are even on wait lists. So I do think it's a word of mouth thing, a grassroots thing, possibly an internet thing. But
Well, I can just say we're not open yet, and we've had many people ask us, when are we going to be open? So we attend national conferences of the National Alliance of Mental Illness. There's always interest at those. There's a residential treatment association group that does sort of a group website. Quite frankly, right now, the internet is where a lot of people get their information. So when they decide that residential, supportive residential community environment is a viable alternative to them, either because it's recommended to them because of their physician, or the family's decided that that's the sort of thing that they would like to look for their child, it wouldn't be uncommon for them to start searching on the internet and get personal recommendations from their care providers.
one thing I wanted to clarify as well, Steve had just mentioned this. As you all know, we are asking for accommodations. So when you're doing your analysis, to the extent that you get to an issue that you say, well, this doesn't fall squarely within our zoning ordinance, that's where you would need to take a look at the accommodation request. So for example, you guys just went through some analysis about the therapy use being permitted in the ag district as ancillary to the convalescent home, but that therapy wouldn't be permitted in your view in the PLS district because it's not specifically permitted. That's where you would take that next step to say, would an accommodation be reasonable? And we very much think that an accommodation to say that is an arbitrary moving line, that it would be more than reasonable to allow therapy on one side of the arbitrary line as it is on the other.
You can certainly consider that. I don't necessarily agree because the property owner still has adequate room on the property to conduct the therapy use. That would be true if they're saying, well, the ordinance allows us to do everything else, therapy, which is part of what we need to do here, then I agree that the reasonable accommodation provision would have to be considered. But here you have on the same property adequate space to conduct that activity. We may have a disagreement here on this issue, but that's where I'm at.
My question is going to come back to the same general area. Do we have to look at this entire application as a package, or can parts of it be denied and parts of it accepted?
Well, I guess the one example
The rest
related to the therapy.
Well, the therapy.
It is, but the therapy is based upon the convalescent request, which is in the MAF district. So you have to look at what are the principal uses being requested of in each of these districts. And either they meet the ordinance or they don't meet the ordinance. If they don't meet the ordinance, is this a situation where a reasonable accommodation is required because the only reason they don't meet the ordinance is related directly to their protected class of being disabled persons?
Once again, though, pick the restaurant. If we say that it doesn't meet the definition of a restaurant, and it's being used for some other purpose.
Well, give me an example.
That's it.
Okay. And then you say, here's how you do it. I mean, let's say it is a restaurant, because that's what's being asked for. Let's say that the planning commission approves the restaurant. If it's being used for something else in contravention of what it's approved for, that's an enforcement issue for staff.
But if we say that it is not being used as a restaurant, it's not being proposed by what they're going to do there, the use is not a restaurant. Can we turn that down as part of this package and approve other parts of it?
I think I'm going to wait until we see if we get there. I mean, do you have a basis right now on that issue?
I personally feel that it is not a restaurant. It's not going to be used as a restaurant. There will be some eating there, but it doesn't fit the definition of a restaurant. It doesn't matter whether they're disabled individuals or fully capable individuals. It wouldn't be used. Wouldn't be allowed. So, is this a package deal? The entire thing has to be accepted, or can parts of it be accepted and parts of it denied?
Well, you have a variety of applications and procedures, so parts of it would be accepted, potentially parts of it would be denied because you have different standards here. I think, in fact, some of the findings of fact talk about that, where they're isolated in the MAF district and other issues are isolated in the PLS district.
Yeah, but if you pick the PLS, which is where the restaurant is, do all the requests in the PLS district have to be approved, or can they be selectively approved or selectively denied?
Yeah, you can selectively deny it, but then you have to look at the reasonable accommodation issue
Right.
to see if it applies.
Right.
It's denied.
Do we feel comfortable going forward, or do we need more thought time here?
Well, from my personal standpoint, there's been a couple of things thrown into this that I hadn't anticipated before. The adult foster care aspect of it, I hadn't even thought of it in that context. To me, my way of thinking, it's different than a rehab facility of some type.
It really does change
And I also think the possibility of a split approval, or portions being denied, portions being approved. I think that's something we haven't done or looked at before, so I think it's important we look at the restaurant and the therapy use and those kinds of things. We've got to get a handle on those, because there's a difference of opinion between you and the applicant, and you guys are experts, so we definitely have some differences of opinion. So I'm not sure we're ready with the adult foster care and those kinds of things coming up to make a decision tonight.
What I do suggest, though, is that use what time is it? I didn't put my watch. 8:30. We have some time, to dig into some of these issues. I mean, Chuck, if you got issues with the restaurant and your opinion as to why it's not there, there's no reason why it can't be aired at this time, at least on the restaurant. It looks like you were prepared to discuss that. So I don't see why we should close the book right now without at least having a discussion on some of these issues and getting them out while you have a little bit of time. Not that I want to keep you here all night. I don't think anybody does. But
The amount of time I've spent on this, it doesn't make any difference if I stay here all night tonight or not.
Well, that's up to you. We're here to serve the planning commission, not the other way around. We're serving the public. So
Have fun.
Start going for it here. And probably a lot of your interactions, not necessarily with me, but it's going to be with the applicant, with staff on that. So if you want to start with that topic here, rather than digging, because you don't have to dig into the findings of fact, you can dig into your select topics here and see if you can get your answers and your ideas of where you're going and whether you feel they're right or not right. So go ahead.
Originally, when in Lake and Stream, okay, if I'm following the connections here, we cannot have a therapy in Lake and Stream. That was decided somehow.
No, it wasn't decided yet.
Can we have therapy in Lake and Stream?
Depends on whether it's an accessory use.
Accessory use to what?
Whatever is proposed.
Which is a restaurant.
A restaurant and cabin column.
Okay, so right now it's considered a restaurant.
And a cabin column. That's what,
Okay. Okay. All right.
And I think I just want to try to clarify something. We've talked about some confusion with regards to the state categorizing this as a foster home. You're still being asked to evaluate the uses in the application. Probably most importantly, the cabin colony use and convalescent home use. So that's
which aren't defined.
There's definitions for cabin and convalescent home that you can use
Yeah,
yourself, which we
but not a
we
cabin
discussed.
house.
Not
Correct.
cabin
That's
house.
correct.
So even though that now adult foster care comes into play, we don't consider that at all?
It's not.
I mean,
Isn't that just the licensing? I mean, it's
Well,
not
no,
necessarily
the
a
use,
foster
the
care.
use.
The use is what they're saying, that the use is an adult foster care.
That's the state makes
The
it.
state.
The state may say that,
Yeah.
but the use is what it is, and you know, by throwing it into the wings there, you have a little bit of confusion there. So that's why I think the question is very important. All right, if the state, you can ask the applicant, if the state considers it an adult foster care, why, you know, that sounds different than a convalescent home. Why is that not different than a convalescent home, which is a use we have defined in our ordinance? There's the type of question that you would ask. This is your time here to go and ask these questions of the applicant and see if we can get some clarity on it. It's your right to do so.
Could you please respond to that question?
Sure. As far as whether or not the state treats it as an adult foster care facility, that's a licensing issue and is actually kind of part and parcel to how you approve it. Because the state could also very well treat it as a convalescent home. So as strange as it sounds, the licensing terminology, and the zoning terminology may not be one and the same, or may actually be one and the same. That's part of where the state's at too with confusion. So once this is approved, we very much may end up with a license under a convalescent home or under adult foster care, or possibly under something else. This type of use that we are dealing with of a therapeutic farm community is so new that the state's kind of coming across different ways to license or approve them as well.
I guess the other element, we're confronted with a lot of different variations of this as a result of these two zones, and then things don't quite fit right. So then you have to get into combinations and things that, although you're asking the questions, sometimes they don't seem to be the right questions we should be working on. But I guess the part of the homework we have is to go back and rethink some of these things as a basis of this. I would say, and I would ask the applicants to go back, because we recommended some things today that you could think about that could simplify this. And I think what we're trying to do is work this issue out in some manner. And we had some different things there that could be changed that would simplify this process considerably. So that may be something you would consider too.
I hate to bring this up, but at the last meeting and the correspondence that we have received, safety and security was a big problem. And it was brought up earlier this evening, but I don't think it was addressed satisfactorily. And you're dealing with a class of people, from what my limited knowledge recognizes, is it can be very unpredictable. Now, there's going to be staff dated 24 hours, but they got to sleep. There has been no talking of security. There's no talking of fencing. And I'm not saying that's the answer, but I think security in all of our discussions has been tremendously lacking.
Stuart, the problem with that is that if you use as a basis the disability, the mental disabilities of those people that will be residing on the property as a basis for denial, that's where you're running into the problem. So unfortunately, under the federal law, you can't look at it that way. You have to look at it, regardless of whether they have a disability or don't have a disability, a mental disability. The only way it really plays into it, the disability, whether it's mental, physical, or other protected class of the disabled, has to do with the therapy use being proposed in the AF district. And of course, they're making a request for reasonable accommodation for therapy. The PLS, we've kind of gone over that. I'm not so sure that that's something that I would endorse, although you certainly could do so as a planning commission, and whatever decision you make, I do my best to support it and defend it. I still am interested, though, in what is up and coming on the restaurant, because I haven't heard that one yet. I'm waiting for Chuck to unload it. So.
Okay. Once again, our regulation doesn't define a restaurant.
I'm trying to help out.
I don't want to get into it, but several years ago I proposed to the Planning Commission we take one meeting a month and start through with the letter A and go right on through and come up with better definitions for the terms that are used in regulation that don't have a definition. And I think we got to about AC or something like that. Never got past it, but anyway. So we don't have a definition of restaurant. So we come back to dear old Webster or somebody else is going to say what they think it is. And the best as I can ascertain by going through a bunch of them is that a restaurant serves food to the general public, generally from a menu with fixed prices during stated business hours. And that's what a restaurant is. The applicant states that the facility and admits that it is really a restaurant. But that's what they're going to try and hang their analogy on. And the only part of that definition that I'm rounding up from several different sources that fits is there's food prepared and consumed on the premises. It doesn't fit any of the other criteria of a restaurant.
I think it's paid for, though. I mean, there's a fee, I assume.
Well, it's in an overall charge for being in the facility. There's no menu, there's no price list on the food. If they want filet mignon, they can't, it's not a restaurant as I look at the common definition of a restaurant.
Okay. Is cafeteria allowed? I'm going to ask staff this because I don't have the screen. Anywhere in the ordinance?
No.
It's not?
No.
So that'd be, may have an issue of exclusionary zoning there, right?
It could be.
Why? Because there's a legitimate governmental interest in not allowing for cafeterias in any zoning district in Cheboygan County?
Yes, sir. Wow. I mean, I was looking at District 4 Health here, and he's the one that says yea or nay.
Yeah. Do you have them in Cheboygan County cafeteria?
Well, we used to.
They're all accessory.
There used to be a couple of them in town.
Are they all accessory uses?
Excuse me.
Accessory.
There's many voices talking at once, and I
Okay.
cannot get an accurate record. I asked this potential.
Go ahead.
Cafeterias. We do have some. Schools have them.
They're accessory uses.
Accessory use.
Okay. Would it be accessory to the cabin colony if they don't have cooking facilities? I'm just trying to help you. I'm just putting out questions. But
Then you're going to get back to the fact we don't have a definition of cabin colony, and I gave you that.
But it's wide open. You can have a cabin colony for any reason. Maybe you don't like that, and maybe that's the change. That's one of those phrases. If you get to AC, maybe it's time to get down to C. I don't know. It's kind of what you're stuck with. I can help you. I'm not a planner. We have planning staff here. I've rewritten ordinances. I know that you can run into problems with ordinances and you run into problems when you have complex and complicated facts. And you end up with situations that you don't want to necessarily be in, but you're stuck with what the ordinance says.
Well,
And
let's fall back then on just cabin.
Okay.
And I assume that cabin colony would be
Consisting of
a group
cabins. That's right.
All right. So the definition we do have a definition of cabin.
You do.
Yes. That's any building, tent, or similar structure which is maintained, offered, or used for dwelling or sleeping quarters for transients or temporary residents, but shall not include what are commonly designated as hotels, lodges, houses, or tourist homes.
Mm-hmm.
use as I see they're proposing it would fit into one of those latter categories that are not falling under the definition of a cabin.
Which one?
Hotels? Didn't a hotel. Unless you break the rooms down and scatter them across the...
So would that be true if it was like my example with a retreat, all right, where they have a cabin colony for a retreat. They're up there for several months of the year, and they're using the cafeteria as an accessory use. Would that also be forbidden then under the ordinance? Why would that be considered a hotel?
I would consider it more of a lodge.
In what sense is a cabin colony never a lodge to begin with? I mean, let's go back to the ones that you've approved. What are those? Are those like hotels and lodges?
No.
What are they like? What are they? The ones that you've approved?
Individual rental units for temporary stays for recreational purposes. That's it.
So why is that not like a hotel? Why would that not be more like a hotel than what's being proposed?
Well, cabin excludes hotel. The definition of cabin excludes hotels.
That's right. So the ones that you've approved in the past, though, tend to have more hotel-like use from what you just told me as opposed to what this one is. So this one's actually more conforming than the ones that already have been approved.
I don't follow you.
Well, the other ones are temporary, for being used for a rental basis or for temporary lodging, right? The ones that you've approved already, that you mentioned
right.
in the past. Okay? So if they're used for rental, like a hotel room, you've seen these cabin court hotels before. They're more popular on the old Route 66, but they still exist in the UP and in other areas. Right. They're a hotel, but they're consisting of individual cabins, but they're more like a hotel. I'm not so sure that this one, as being proposed, is more like a hotel, and it appears to be factually less like a hotel. But
the definition says any building, tent, or similar structure, we're still on the same page, which is maintained, offered, or used for dwelling or sleeping quarters, we're still there, for transients or temporary residence, still there, but shall not include what are commonly designated as hotels, lodges, houses, or tourist homes.
Yes.
So these cabin colonies, as we have them, meet the definition of a group of those cabins. I don't think they meet the definition of a hotel, which isn't defined either.
Yeah, because they're not, I mean, look at let me get on the same, I think we're shooting
definitions.
We're going this way here, so.
Page 7 of it.
Yeah, not include what are commonly designated as a hotel. Well, that example I provided of the court cabin hotel that you find in the UP would be more like a hotel, okay, instead of a cabin colony, even if they call it like a resort or something of that nature. The ones that you told me you've approved in the past tend to be rented out, right?
That's right.
Okay, just like you rent out temporarily a hotel room, right?
From that standpoint, yeah, but we're making a distinction between cabin and hotel.
That's right, because you don't want your cabin colonies to be designated as a hotel.
That's correct.
Okay, or a tourist home or a lodge.
Right.
Okay, these are simply for temporary dwelling. Temporary is not defined. Temporary can be, and although I think the applicant, you can ask the applicant again that most of the residents from what they propose would be there for less than a year. Some for a few months, some for up to a year. That's my recollection on that.
That's correct.
Be temporary. So if anything, this cabin colony could appear to be something that would fit within the definition. Perhaps more so than what has already been approved by the county under zoning. Now, I could use Scott or Steve as a foil. They could disagree and come up with an example that's opposite. I'm waiting for them to do so.
I was hoping you might do that. You've made
Okay.
examples on the other end the entire evening. I'm just wondering what you might think of on the other side, whether it's even this case.
Sometimes you have a hard time doing it. Sometimes it's easy to have a hard time doing it. When I'm drafting findings of fact for variances, it's much easier to have it all one-sided because it's very rare that a person can meet the standards to get a variance, a dimensional variance under the ordinance, as you know. And Chuck, are you still on the ZBA too? Or?
Chairman.
You're chairman, that's what I thought. It's just been a while since I've been in front of the ZBA. When it comes to special land uses, you have more in the way of discretion. And I want to mention, because this hasn't been mentioned thus far here, but I don't want to shut out the township. The township had a meeting, at the end of October, and they didn't like the fact that they said it didn't conform with the master plan. But under I think it's in the master plan of Cheboygan County, the master plan of the township is considered when you're engaging in legislative acts, such as amending the zoning ordinance or making a change. That's why it was very important that what was it called, the monster guy who had the Griswold Mountain, okay. That was a legislative act because they were asking for conditional rezoning, and the township's input was critical there because of the rezoning. Unfortunately, in this case, it's not, you're administering the ordinance, so that input is not as relevant. That's why I didn't include that in the findings. I thought one of you would bring that up, and I don't want to be disrespectful to the township, but it doesn't apply to administrating the zoning ordinance. But yes, you can often have a variety of different choices here on what to do. I did provide some where I thought I could utilize it. I really did study Bridget Brown Powers' 40-page memo and all the material she provided. Even in a couple cases, I guess I came up with findings that were supportive of it using some of the exhibits that Bridget had provided. Not so much, out of the brief, but I did come up with some findings that were against, based upon some of Bridget's analysis and my follow-up on it. But my follow-up and the drafting that I did was the best that I could do given the facts and circumstances of the application, the state law, and then what's before us. I'm trying to do my best, to protect the client and make sure that you have the best information possible. This is new stuff here. This is difficult. It's difficult to absorb. It's difficult to comprehend. It's difficult politically when we have, the potential hammer of litigation and all the fund damages that come along with a federal case. You can't consider that. You can only consider what the federal law requires you to do. And it does push you in a direction in certain circumstances where if your decision, again, is based upon the disability of what's going on here. And that's why I'm really trying to separate the disability to see if we can get through this without even having to hit upon the federal area. Once again, the example of where the applicant would like you to use the federal area has to do with the therapy, but because they have ability and property to conduct therapy in one part of that zoning district, they can go ahead and do so there. I don't see a damage claim that's viable based upon it. I just don't. Okay. They're going to disagree. Maybe if it gets approved without that, who knows? There could be litigation over that, but I'm more comfortable in that area. But, getting back to your cabin colony, you have to go with what you have, okay? And, we've discussed the past practices here of how they've been approved. And as proposed here, they match that use more closely and match the definition of the cabins themselves. Now, they're not going to have any additional facilities on there. And frankly, they have to go with that because that option is available and they don't have the choice of going with duplexes and regular housing under the ordinance because of the density issue and was it the Lake Shore as well, Steve? There it wouldn't work, and it wouldn't work regardless of whether they're disabled or whether the people applying for it were not disabled, so it wouldn't help them on a reasonable accommodation, particularly when you already have a use that already basically allows them to get that density. Okay. Cafeteria. I guess it would be an accessory use. It was applied for, as a primary use as a restaurant. If you determine that it's not a restaurant, it is logical to look at whether that cafeteria is an accessory use for people who are in that cabin colony. Seems to be fairly logical. if you exclude it otherwise, and cafeteria is not considered an accessory use, it's certainly not considered a primary use anywhere under your zoning ordinance. And you want to run it up that flagpole, that hits you with exclusionary zoning.
Restaurant is.
Restaurant is, but not cafeteria.
But they've asked for a restaurant. Their analogy is to a restaurant, not to a cafeteria.
That's right.
So is it a restaurant or not?
No, if it's not a restaurant, the cafeteria, if it's an accessory use, is that an issue that's passed upon by the planning commission, or is the accessory use something that's dealt with by state?
I think in the application they mentioned restaurant/dining hall. So as far as terminology goes, they've asked for that.
Let's say we skip the restaurant and it's a dining hall. Would that be, if it's not a primary use, you couldn't apply for it because it's not a primary use in any portion of the zoning ordinance, right?
Then it's up to the planning commission to decide if that's naturally or normally incidental use to the primary use.
Okay. And are cafeterias and other uses, have they been considered incidental, in the application of the ordinance to other uses?
I might defer to Chuck and others who've been here longer.
Not that I know of. The only time we've come up with them is not as a cafeteria, it's been as a restaurant, where they were specifically authorized.
Well, it's probably not unusual in a rural county like Cheboygan County. I mean, if you were in a more densely populated county that had, for example, a factory, where the factory workers would have their cafeteria in there, if the factory was allowed by special use.
Well, but the question is,
would the cafeteria be
the restaurant? The restaurant can be in either of these districts.
No, I'm playing the advocate that you're saying the restaurant's not it. Okay, it's not a restaurant. Let's assume the planning commission says it's not a restaurant. It's a cafeteria. It's a dining hall, which is not a restaurant under the ordinance. Then you have to consider, is that an accessory use to the cabin colony? Well, the cabin colonies, they're not allowed under the definition of cabin to have cooking facilities. Could that be considered an accessory use to the cabin colony? Is that reasonable?
Not the way it's been applied in the county.
But it really has been applied.
Cabin colonies that have a restaurant associated with it. Accessory use or otherwise.
Okay.
Now, I can't say we don't have a cafeteria associated with a school or with a
This
hospital.
is where I think maybe that reasonable accommodation provision comes in there, because the claim would be that because of the disability of the occupants of the cabin colony, they're unable to, prepare their own food or do things that other people who would normally occupy such a cabin colony would be able to do, and therefore the cafeteria is necessary as a reasonable accommodation. That probably is fairly logical.
And then you get back into the fact that they're just eliminating the cooking facility of the units that are on that side of the line, and they've got them in the units on the other side of the line.
Well, that I'm not aware of. We can ask that question to the applicant.
That's incorrect. We don't have cooking facilities in any of the cabin colonies.
That wasn't what was said in the last meeting.
You just said they did have.
The cabin colonies have a small refrigerator and a microwave. That's just considered efficiency. That's not a cooking facility. There is no stove or oven or other cooking facility for these people. They cannot prepare their own food, and that is part of our previous submission. That's the reason that there is a dining hall.
Then how would they be mixed residential? So there's a residential component up there as well as for handicapped folks. How would it be classified as a residential unit and having people live in it if there's no cooking facilities?
I'm not sure I fully understand the question. They're residing there, but they don't have their own cooking facilities due to their disability, similar to a convalescent home. Each unit in a convalescent home wouldn't have their own cooking facilities either.
Okay.
Who determines the definition of cooking facility? I know lots of people that, can you cook with a microwave?
I don't. I never cook on a stove. I got a whole house. I cook.
Well, I think that's a staff. I'm going to let you do on that one. I think we're really
Yeah, I guess to respond to that, I'll go back to the previous comments here. We're looking at requests for cabin colonies. We're not looking at requests for, or at least we're not evaluating the requests for multifamily or duplex or any type of dwelling as we define a dwelling. You have to look at the cabin colony definition and see if you believe that applies. It's kind of restating what I said before, but that's what that's going to apply.
Also, we know that they applied for that. We know that the cabins don't have cooking facilities. You've determined that in the past, and you can stop me at any time here, they did not have cafeterias or dining halls as an accessory use with the cabin colony from your recollection in the county. That does then bring up the issue of the disability and the reasonable accommodation for the dining facility, given that there's no cooking facilities. And I guess I'd like to ask the applicant, is there a reason that there's no cooking facilities and the dining hall is needed? Is it because of the disability of the residents
Yes, correct.
on the property? It kind of brings you back to, that's kind of the package that's being presented here. I'm not saying you have to like it.
Yeah, and I have to defer to Peter in regards to the accommodation.
But I think that's one where the accommodation issue kicks in. Because there's a reason they have that accessory use that otherwise it wouldn't exist, right? And that reason has to do with the disability of the residents here. It's not illogical, and I think, frankly, the court would look at that and support that. I'm just making you guys happy all night long here. But you have other questions too, I assume, on other areas. I mean, are you getting tired or are you ready to keep going?
One last thing, and then I think I've got most of my questions answered. I think where we stand right now is lots of new data presented to us. We're going to be, with no changes, we'll make that decision. I mean,
Sure.
We'll figure out one way or the other. And let's say it was not approved. Because if it were approved, everything goes on as normal. Outside of, you might hear lawsuits from the other side. But if we don't approve it, then I think we are in some kind of a legal problem. That'll cost money. And away we'll go.
But again, yeah, I'm trying to provide advice saying what the law requires. I'm not so, you can't be concerned about what the damages are. You have to make your decision based upon the ordinance and the law.
I understand that.
Not on the threat of any damage claim, but and that's where I'm trying to help you out.
I understand that. I'm just saying we presented some other information, and I hope the applicants have learned there are some other ways to look at this thing too. That reasonably, I think we could work this out. But so that's all I'm saying. Is, I think that you just have to assign the risks associated with these paths and say what do we think is best for us and what do you think is best for the applicant. Hopefully there's some common ground that we can come to.
If the planning commission then wants to have a little bit more think time, I do recommend that at the next meeting we're going to have to make the decision here. My advice would be that individually as part of your preparation, obviously not in a manner which violates the Open Meetings Act, but as part of your own individual preparation, that if you have questions individually, you bring them to staff. Okay? And staff either will be able to answer a lot of them on their own. If they need any help from me, they'll ask for that, and I'll make sure that your questions are asked. And staff, of course, will be in contact with the applicant to make sure that any questions that have to go through the applicant are answered by them as well.
One thing I could say too is that some of the conversation that I heard here tonight is very similar to the conversations Scott and I have had in trying to get our minds around this very complex application. I think one thing as I've been hearing the discussion tonight is I keep coming back to the very cover page of the packet here tonight and the public notice that went out. It's really tempting to look at this and say, I can think of a better way through this because there are many options. It's not a round peg, round hole for the situation as the applicant has stated early on. It's really tempting to think about other options that you think may work better. The applicant has chosen this route after having a lot of consultation with us and with their own attorneys about conditional rezoning, variances, and rezoning, a lot of different things. We even tossed around the idea of what should we do with child caring institutions where, we worked, because we heard there was a demand, we worked on a definition independent of the application and amended the ordinance so that it was, it took care of child caring institutions. It was a long process. That just keep coming back to the fact that this is what the applicant has chosen, this is their path, and those uses that are listed in that public notice are the ones that you need to really focus on. And I think, and especially tonight, and it is 9 o'clock already, but any of those questions, I think that therapy use idea keeps coming up, and I know that I've felt like there, from the conversation tonight, that there's maybe still a few questions about what the details are of that, and maybe I could just suggest, since we're here, if there are more questions about the therapy use, that those be clarified. That's just some reflection from the conversation.
Nobody wants to talk to me.
I love talking. You're always interesting. So you always think about everything, Chuck. That's good. That's why you're on the board.
What kind of staff are you going to have at the facility? What are their qualifications?
I believe we've answered this multiple times the best that we can. They will be people who have all required medical licenses as medical professionals.
That's fine, but what are they? Give me the type of licenses that you're speaking of. It's psychiatrists, psychologists?
Yes, correct, both.
Both on staff?
Therapists. Yeah, there's multiple different levels of therapists as well. So, I mean, that's the thing is, at this point in the business plan, we can't commit to saying to you, we will have X number of people at the limited licensed psychologist level and X number of people at a full-blown psychiatrist level.
I'm not asking for the number. I'm just asking what types of service you're going to have available. Not whether there's going to be 3 psychologists and 4 psychiatrists or 1 psychiatrist and 2 counselors, or I'm just looking at what types of people are going to be there on a permanent basis.
Sure. Well, I let Betsy address the specifics, but they will be anybody that would be part and parcel to a convalescent type home or a therapeutic community type home, which we can't specifically commit to absent having a business. So we couldn't tell you today that we will have psychiatrists but not psychologists, or we will not have a chef, or we will have a chef. Those are things that will come up as the business grows. But I can let Betsy discuss, generalized plans with you at this point.
I think the best way for me to discuss, and again, as a generalized plan, because we don't have a first resident there, we will have a psychiatrist that will be affiliated with Heritage Cove Farm. We will have psychologists. We will have therapists, probably counselors, and then other staff. There will be staff there to care for animals. There will be staff there to provide the meals. There will be staff there to take care of the maintenance of the facilities. So those are the general staff, and I believe a lot of that is in the materials that we provided you with.
Okay, these are resident staff then, not somebody that's going to be online or...
No, they wouldn't necessarily be living there, all of them, no.
But when they're providing the services, are they going to be on site?
Psychiatrists, we quite frankly expect many of the people will continue with their psychiatrists and use telepsychiatry. which is very common, especially in northern Michigan. I'm not sure if you're familiar with that.
Well, I'm familiar with what you'd be doing that way. I'm not computer literate, nor am I able to communicate that way. But
well, it's actually quite common throughout the medical industry and the medical field. We can't have specialists up here. We don't have the specialists we'd like to have here on a full-time basis. But we will have a local psychiatrist that, yes, will be coming to the facility. For those people that want to continue with their therapy, though, with their local psychiatrists, are certainly going to be able to. And quite frankly, I see, that is a tremendous resource that will be currently available up here. So,
well, I'm all for it. I personally would like to see a lot more available in the way of mental health support. I've got a lot of personal background with people that have disabilities of that type in my own immediate family. And I don't think that the mental health system right now is adequate in any way to support the people that need it.
I would agree with you.
I've had 3 members of my family that spent most of their adult lives in the old system of state health hospitals, mental health hospitals, with the old shock treatment being primary treatment facilities. And I still have a number of people in the family that are bipolar or have similar disabilities. So there's a wide range between what the system avails itself of in the way of putting somebody away because they're a hazard to themselves or others, and being free with no restrictions. There should be some way of determining people that have a need, do need some guidance, and do need some help, and that's not available to them right now. I don't think there's a way of getting the people in the middle. Either up, down, out on one end where you don't require any kind of support, or you're on the other end where they lock you up. And in between, there isn't much.
Thank you. I think you'd be a really good spokesperson for Heritage Cove Farm.
All right.
Okay. Do we want to continue this at our next meeting? Is there sufficient time on the agenda?
I had one thing real quick that wasn't addressed. When you do continue your deliberations, I know you did spend a lot of time today discussing the restaurant use, but I did want to point out that in the current pending request and the prior request, the community house building is proposed as analogous to 3 different items that each should be reviewed and determined. So in addition to the restaurant, the other possible options for analogizing were the club use, and we would be looking at the community house would the dining hall type facilities and the therapy type facilities be part and parcel to a club. And then the other one is the country club use under 10.3.6. So that community house building was proposed under 3 different options. And then obviously, as we've discussed, any and all accommodations.
All right. Our next agenda, I was just looking at it, it's kind of with Brian doing a couple of things. So shall we recess this discussion until the first meeting in January?
Yes, I think we can do that.
The size of the crowd tonight would fit
We could be in Commissioner's
It's risky if more people show up at the next one. We do have the Opera House available. The first 3 Wednesdays, they said, are available if need be. So you could just have it there to be safe. But this is not available in January.
Well, with this size crowd, we could use the Commissioner's room without any problem. So, unless we end up with a bigger crowd. Is that all right with everybody, or?
Sure. Could we go up to the circuit court?
If it's too big.
I don't remember if that was bigger or not.
It is.
Yeah, it is. Is it bigger?
We've done it in the past.
I don't know if the seating is there in the circuit court as it is in the commissioner's room, because there's room to put extra chairs in the commissioner's room.
It's bigger, but there's not necessarily more seating.
Right.
You got the jury box and
I do recall that when we were having the marijuana discussion, medical marijuana discussion, we had 105 people in our room.
Mm-hmm.
So I look at this and I think, well, okay, we're not going to have a problem. Then we run the risk, though, if you do get too many people and they're out in the hallway, then you're going to have to shut it down.
Mm-hmm.
So,
which violates the Open Meetings Act,
Yeah.
so you can't do that.
This is about 35 people. We can handle about 60. I think it's about 50, 60 in the audience, if I remember right.
So, why don't we just table this until the first meeting in January, and we'll go for the commissioner's room.
So moved.
Okay, motion and support. All in favor?
Aye.
Opposed? Motion carried. Do we have any other unfinished business? Any new business?
we don't.
Okay, any staff report?
No staff report at this time.
Okay, planning commission comments?
Good meeting.
Steve?
Just briefly, it's not an official staff report, but talking about definitions, I think on your work plan for next year, we're talking about redoing the matrix for all the different uses. We were thinking it was a great time to be looking at the definitions.
Right. Definitions.
And simplifying the list of allowable uses.
And we started work toward that. It'll be a little while before it gets to you, but it started.
Good. Okay, do we have any public comment?
I do have a request from the applicant. Is it possible under your rules and your ordinance to call a sooner special meeting versus waiting another month, as the application has been pending for quite a while? Obviously, our last hearing was a full month ago, so we've now had 2 hearings on this, and now this is being pushed out yet another month. I thought that was something that Council, Mr. Christine had mentioned to me about. I thought a special meeting within a couple weeks.
It would depend on scheduling. I'm going to take that, Steve.
Yeah. The only thing that Hyder and I talked about was that there was January 6th was really the next available meeting. I think the other ones had to do with holidays. We were thinking we would need a larger facility at that point, and none of the other larger facilities would be available before January 6th. So no, we didn't have that opportunity. So I think January 6th is going to be the next available one. I think the 30th, if we do have it in the commissioner's room, I think the 30th is the 5th Wednesday of December, but that's pretty close to holidays for people also.
But you've already determined you're going to have it in the commissioner's room, so it doesn't have to be any particular day of the week.
No, we typically look at Wednesdays only because you all keep those open. So.
If they wanted to propose some other day in the next, say, 2 weeks down the line, it would depend on how many of us could show up at that meeting.
Right.
A special meeting is not out of reason.
I think that's a good suggestion.
There's a special meeting request fee of $400 to have that because of extra staff time and all that.
Is there any advertising?
Special, why can't it just be the next meeting, third Wednesday?
Yeah, let's do that.
Yeah, we have a couple of special
already that meeting.
That's on the schedule already.
I know. But it's pretty
Couple applications, those are straightforward.
They're straightforward.
Has it been advertised? Is there an advertising period that we're up against to add it to that?
Yes, there is a public hearing on a special use permit request that the next meeting is set for. That is already been closed.
So we couldn't add this to that. This has to be advertised.
Does not. If you go at that meeting as well, I suppose, you could have other things going on. You wouldn't have the time to devote to this, or you may not desire to put the time to devote to this as you might.
Personally, if we added it to it, and we didn't get through it, they'd be, at least have the chance of having it.
Can we reschedule Brian in PED?
Yeah, I'm sure we can. We can do it.
If we reschedule those and put this on the agenda for the next meeting.
I'm in favor of that.
Yeah, that's fine with me.
I mean, we're going to try to accommodate them as best we can.
Yeah, because it's been going on.
Just reschedule the other stuff.
So is that the 16th?
Yeah.
That's fine with me.
Are we looking at?
Yeah.
Are we looking at the 16th of December? So
Yes.
That's correct.
Okay, and would that be at the same time?
Yes.
Okay. I do also request that you waive the $400 fee.
That's not a special
It's
meeting.
not,
That would be a special
putting it on a regular agenda.
Reworking our agenda for our
Very
next
good.
meeting.
Perfect. Thank you.
Okay, would you get a hold of Brian in the morning?
Yeah, I'll see these changes, and we'll have the special use permit, the other special use permit, I request on the agenda as well as this, and what's up to the items that's on the agenda.
We both have site plan review.
Yeah, yeah.
Okay. All right. Okay, if nothing else, I'll entertain a motion to adjourn.
So moved.
All right, thank you.
Thank you all for your time.
Yeah, well done.